Hello everyone, welcome to the Spardha line. In today's focus line, we are going to discuss the many articles which are very important from the men's perspective as well as from GS and GS3. So we are going to discuss this article. First article is about the recent Supreme Court judgment about the Waqf Act and what is the Supreme Court judgment, what is the implication of this. Second, in GS3, where we are going to discuss the decrease in trade deficit. Particularly, we are going to see the reasons behind it. In third article, that is very important from GS4 as well as GS2 perspective, it is about the caste crimes and the anticipatory bail. In last article, which is important from GS1, that comes in society as well as GS2, because it is part of the Mental Health Care Act, and GS4, the issue being the mental health. So these all are 4 articles we are going to discuss today. So we'll start with the first article, which is about the Supreme Court's judgment in the Waqf Amendment Act that came in last year. So the key changes introduced in this amendment are, so first is about the practicing Islam for 5 years. So the person who wants to give or donate the Waqf, so that person must practice the Islam for 5 years. So this is one arbitrary clause introduced in this amendment. Second is about the Waqf, that user doctrine removed from the future Waqf. So the user doctrine which says that if particular person or he already donated some land, and that is land with not Waqf for a long time, but it is used for the religious purpose, so then automatically it is considered as a Waqf land. So that was the one user doctrine, and this doctrine removed from this particular amendment. Again, one more change introduced, that is about the executive and administrative power. So the district magistrate and the other state authorities, so they will get the power to decide whether the land belongs to Waqf or not. So this is one more introduction. Then next is it is inclusion of non-Muslim members on the state Waqf board as well as central Waqf council. So this is the new change that introduced in this amendment. Last one is the Limitation Act. Previously, this Limitation Act was not applicable to any Waqf provision, but certain provision that brought under this Limitation Act. So this is one more change introduced. So the Supreme Court that seen all these controversial amendments, and it has given the verdict belongs from this perspective. So it has says that this particular provision, that practicing Islam for 5 years, it is quite arbitrary, because the individual, it is against the freedom of religion, and no one can decide whether the person is practicing Islam or not, because there is again the right to privacy. Some may practice in privately, or some might practice in publicly. So this is the one more clause that introduced. It is become very controversial. Second is about the user doctrine. So it is Supreme Court still now it is kept on the hold. So it is upholded this one. So there is no controversy regarding this second amendment. Third is about this executive power. So Supreme Court said that it is against the separation of power, because the particular land belongs to Waqf or not, that will be decided by the administrative machinery, and it is against separation of power. So this also Supreme Court has given some direction regarding this. Next is about the inclusion of the non-Muslim members. So which was the new provision. Supreme Court said that set certain limit, that there should be only 4 members who are the non-Muslim in the state Waqf board as well as the central Waqf council, and the chairmen of this state Waqf board or the central Waqf council, they should be exclusively Muslim. So this is one more change or the direction given by the Supreme Court. Next is about what is the legal or constitutional issue raised in this case. So first is about the freedom of religion. Okay, because if you see Article 25 to Article 28. So this is all about the freedom of religion, and this particular act says that to grant the donation as a Waqf, the person should practice Islam for 5 years. So this is against the right to privacy as well as the freedom of religion. Second is about right to equality and the non-discrimination, because again the same provision that person need to prove that he is practicing Islam for 5 years. That is again the controversial, which is against right to equality, that is Article 14. And also it is discriminated person who is practicing and non-practicing. So there is the person is not from the Muslim, but he wants to donate for work, then it will be discriminate up with such person. So this is the one again controversial. So third is about it is against the separation of power, because if you see the administrative machinery will decide whether the land belongs to Waqf or not. So this is the one controversial, which is against the separation of power. The power lies in the judiciary to whether decide on dispute. So but it is now done by the administration. So that is the against the separation of power. Next is about the rule of law, the property right and due process. The due process, nothing but the process given in the act, but the rule of law, whether it is aligning with the freedom of religion or not. So that is the one issue. Second is about the property right. If person is willfully donating certain lands as a work, so then if you see the property right, that person hold exclusive right on his property and he has all the right to decide on that one. So that is also become one controversial here, because the person is no longer willfully donate his land or his property. Again the due process to discriminate that is given in the particular act. So this is one more controversial. Then again it is against implication that balancing state regulatory power with the religious autonomy. So there is considerably this particular amendment curbed the religious autonomy by giving the power to state exclusive regulatory power on the Waqf donations. So this is one more. Then again it will lead to administrative overreach, because if you see the person like the state government or the central government, they got rights on the to nominate certain people, non-Muslim people, to Waqf boards. So this will give them exclusive or the more right, and it might lead to the discretionary power. Also the deciding on whether the particular that donation belongs to Waqf or not, that is also will lead to administrative overreach. So this is all the observation done by the Supreme Court in this particular bill. Next is about the rise in trade deficit narrowed significantly. So there are the certain reasons why trade deficit narrowed. First is the oil or energy prices that become low, because we have diversified our import basket, because we are importing more oil from the Russia, which is considerably cheap, and this ultimately lead to the low prices. So the prices of the oil that reduce the international market, and automatically it reflected in our import bill. So from that perspective the trade deficit narrowed. So now when it comes to the trade deficit, so if you want to reduce trade deficit, it can be done on two grounds. Either you need to increase the export, or you need to reduce the import. So from these two where the trade deficit can be narrowed down. So these are the two, mostly this reduced import is dominant in this particular factor, because if we see there is the strong service exports. So the service exports are increasing. First it was about the reducing import, second is about the increasing service exports, third is about the again the reducing import, that is the reduction in gold, precious metal imports. Because if you see the after US tariff, what happened? It is directly impacting the jewelry and this diamond industry in India. So for that, like, we are one of the largest importer of this gold and the other precious metal. So the fearing this US tariff and the loss occurring in near future. So from that perspective, there is reduction in the gold and precious metal import. Next is about the export growth and diversification. Particularly when it comes to chemical machinery, we have diversified our export basket, and that perspective, it is led to the export growth and also the stability in the exchange rate. Next is about the import compression and delay, and this is because of the weak demand in Indian market as well as the global market. So this particular aspect lead to the import compression or the delay. Also delay because of the supply chain disruption. So these are the major reasons behind it. Next is about the systematic measures that enable this trade deficit narrowing. So first one is policy push, and that policy push for the particularly service exports. So this is one more reason the trade deficit narrowed down. Second is about the effort to diversify the energy sources. We are buying the cheap Russian oil, but we are not relying on the only sole the Russian oil imports. We are again going for the other. We are buying from the Nigeria, the African country. We are buying from the West Asia. We are buying from US also. So we are diversifying the energy sources. So ultimately, the effective price of import that is decreasing. Next is about the global commodity market trend. So there are the two aspects. First is about the demand. Because of the global slowdown and protectionism, the demand is weakened. And second, because of the US tariff and other the wars happening in the world, the supply side, that supply chain is disrupted. So that through two perspectives, that supply and demand, there is the volatility in global commodity price trend. So these are the all reasons that lead to the narrowing down trade deficit. Next article is about the anticipatory bail in case of caste crimes. So in this particular case, Supreme Court has highlighted, recently ruled that anticipatory bail, it cannot be granted in cases under the Scheduled Caste, Scheduled Tribe Prevention of Atrocity Act 1989. Okay, and there is one section 18 of this act which bars the anticipatory bail for those accused in offense under this act. So there is one section 438 in Criminal Procedure Code or BNSS. So that particular section says that if certain person is detained under the certain provision, it by default he will get the bail. But this particular act, the section 18 of this act, SCST Prevention of Atrocity Act, that bars the anticipatory bail of the accused person. Okay, so this is about the Supreme Court observation. Now next we will see what is exactly development here. So first, before we need to see what are the caste crimes. When it comes to the caste crimes, the caste crimes refers to the offense motivated by the caste identity or of the victim, where the individual belonging to scheduled caste and scheduled tribe are targeted because of their caste. And these offenses include the physical assault, the mental harassment, all kinds of offenses this particular act include under the caste crime. Second is about what is anticipatory bail. So this is the pre-arrest bail. So before arresting, there is a provision of giving the bail, and that is done by under section 438 of the civil CRPC or the BNSS. So this particular the provision is there under this act, but it allows someone who fears that arrest for the non-bailable offenses. So it gives the bail only in the non-bailable offenses, which are non-serious. So he can approach the High Court or the Session Court to secure the bail before his arrest. And it is also discretionary. Discretionary means if the offense is cognizable or non-bailable, bailable, then the person will not get the bill, and it is totally lies on discretion of the Session Court or the High Court or the Supreme Court. So also, if you see the section 18 of the SCST Prevention Act, SCST Act, what it says, it is bars the anticipatory bail. So the person who was accused under this particular act, he cannot get the anticipatory bail. So there is a conflict when it comes to this particular reference of this CRPC and this section of the SCST Prevention of Atrocity Act. So if you see what are the Supreme Court the recent because of this implication, what are the implications because of this ruling? It will uphold the special protection that previously given to the SCST, and this special protection they got from the Constitution, preferably from the Article 14 and Article 17, which is the prevention of untouchability and the right to equality. So these two articles, they got the special protection, and Supreme Court, it upholded this special protection. Second, it also introduced check and balance. So when it comes to this particular section, it applies only for the accused person. If there is no merit, prima facie merit is not involved, that person is allowed to get the bail. So this is one check introduced in particular act. Second is about, it also strengthen legal deterrence. So because it is bringing the all physical and mental harassment under this particular act, and it is effectively giving protection to the SC, ST and other vulnerable communities. So it is strengthening the legal deterrence. So when it comes to this particular bill, that if you see the statistic belongs to the SC, ST atrocities. So there are certain strategies. So in 2022 compared to 2020, the cases of atrocity that gone increased by the 5%. So previously it was around the 51,000. It is gone to the around the 55,000. So this is the 5% increase, and most of the cases, that's around the 97 cases belongs to the ST, and around 98 cases belongs to SC communities under this particular act. They are concentrated only in 13 states, and mostly are the northern state, where the UP only has share of the 23%. So you can see the kind of the caste atrocity prevalent in this particular northern state, particularly the UP, where the UPC 23% cases registered under this particular act. Okay. Second is about the SC. I'll say also the top state when it comes to the ST, it is of MP, where the largest ST population lies. So we see there is certain concentration of this caste atrocities. Next is about the data that is given about the charge sheet. So in 2020, in nearly 60% cases under this act, the charge sheet was filed. Okay, but out of the 60, only 39% cases where the conviction happened, and this conviction rate in 2022, it is came down to 32%. So the conviction rate is also decreasing, and that is concerning under this act. So there are the Supreme Court pronouncement where the Supreme Court has given certain verdict which talks about this particular act. So first is about the Kanubai Parmar case. In Kanubai Parmar case, the Supreme Court says that this particular act, it only applies against the non-SC and ST people. If people belongs to the same community, they are involving in atrocity against their people, then this act will not be applicable there. So this is one significant pronouncement of Supreme Court. Second is about the Rajmal versus Ratan Singh case. So under this provision, there are the special courts to try on this act. So when it comes to the SC and ST Prevention of Atrocity Act, there are the special courts to try this, and Supreme Court is upholded this particular addition, that is special court to try these cases under this SC and ST Atrocities Act. So these are the two important cases when it belongs to particular this act. Okay. Next is about the mental health. So the Supreme Court has declared the mental health and the psychological well-being of the integral part of the fundamental right, where it fundamental right, that Article 21, which is about the right to life. So here under this Article 21, Supreme Court says that the mental health or the psychological well-being is the integral part of the fundamental right, and this came in the case where the NEET student committed suicide. So it is about the Sukhadev Saha versus state of Andhra Pradesh. So in this particular case, Supreme Court has pronounced this judgment, and in this case it added the mental health as a fundamental right. So also it is issued nationwide binding guidelines for the educational institute, because the context was the suicide because of the NEET pressure. Okay, so it has given guidelines where the all institutions with 100 plus students, they must have at least one qualified counselor or psychologist, social worker. Okay, so he can treat the child on this mental health issues. Next is about the institution should avoid the practices, okay, such as the public shaming, segregating students by performance, setting the unrealistic academic targets. So this is the important guideline given by the Supreme Court under this judgment. Next is about, it also told that there need to introduce some safety measures. So safety measures in particularly residential institutions. So what kind of safety measure? There need to be tamper-proof ceiling fan, restricting access to rooftop, balconies. Okay, so person can there should be reduction in the self-harm attempts. So particularly talking about the suicide attempts due to mental pressure or the mental health issues. Then also it introduced uniform mental health policy. So uniform mental health policy need for the all educational institute. Okay, drawing from the existing framework. So it is also important guideline given by the Supreme Court under this particular judgment. So next, when it comes to the mental health, what are the reasons behind the mental health issue? First is from the supply side. So mental health happens because of the certain social factor, and second is if there is no steps taken to reduce it, then again it will aggravate. So need to see from the both perspective. First we will see from the second perspective, that is whether there are certain attempts done to reduce or take care of this mental health issue. First is about the shortfall out of mental health professional and infrastructure. When it comes to the professional, the UN guideline which says that there need of minimum 3 psychiatrists per lakh population, 1000 population. But if you see the India's current infrastructure, it is about the 0.3 per 1000 population. So it is the substantially low. So when it comes to the infrastructure also, it is need currently, if you see India's social structure, it need the nearly 35,000 clinics. But if you see the current infrastructure status, it is around the 1,000. So there are the 1,000 clinics which treat the mental health. So this is also substantially low. Second is about the treatment gap and access barrier. Treatment gap is nothing but whether person is suffering from the mental health issue, he will get the treatment or not. So this treatment gap, it revolves from the 70% to 92%. Means the people with mental health. So out of 100, out of the people which facing the mental health issue, 70% to 90% peoples will not get any treatment. So this is the very concerning issue when it comes to the India's mental health infrastructure. Second is socio-economic stresses. Social economic stresses, nothing but the poverty, the unemployment. So these are the issues which are concerned for the social economical perspective. These are keeping the considerable stress on the mental health, and it is leading to deterioration of the mental health. So this is the major reason behind it. Second is about the awareness, stigma, cultural barrier. So awareness, people are not aware about the mental health issue. They no longer consider mental health is a kind of disease. It is considered as a sign of fatigue or the sign of stress, one more, but it is never seen as an issue. Also there is stigma related to it. A person is telling about he or she has the mental health issue, then that person will be stigmatized. So this is the one major reason. Second is about the cultural barrier. So the cultural barrier, because of the mental health prevalence, if you see, particularly it is among the women, the children's, and when it comes to their financial state, it is the access to financial resources is substantially low, and this cultural barrier aggravating the mental health issue. Next is about the economical burden. Here the If you see the Mental Health Care Act that is brought in 2017, it has given the insurance coverage. But if you see the premium, it is high. So it is effectively reducing the access to mental health facility. Second is about out-of-pocket expenditure. So it is overall pocket expenditure is 49% according to Niti Aayog, but this is only considered to other physical disease. It is not counted the mental health. So if you counted mental health, it is goes beyond the 60%. So this is the one economical burden that middle class family or the Indians are bearing. Next is about the impact of recent crisis such as COVID-19. Okay, other environmental factor like climate change. So these are factor what is creating. It is creating physical stress, and this physical stress, it penetrated into mental illness. Next is about the youth, digital age, lifestyle factor. So if you take this combinedly, what are the current situation of the youth? That is they are busy on the social media. It is virtually, they are connecting them to others, the society, but when they shut down the social media, they are isolated. So they are socially close, but physically they are isolated. So this factor leading to the mental health issues. Next is about the regulatory and the legal policy gap. So I was talking about the Mental Health Act brought in 2017. This particular act brought, but when it comes to the implementation of particular act, it is very low, or there is implementation gap. It is not taken under seriously. Even the some institutions like universities, school, the hospitals, they have got some guidelines on the infrastructure that is also not properly implemented. So these are the reason behind the mental health issue in India. Next is about what are the constitutional and the related act. First, just I told you, in Sukhdev Saha case, Supreme Court says that the mental health, the right to mental health, it is fundamental right under the Article 21, that is the right to life. Second, the particular act brought it, the Mental Health Care Act 2017. So this particular act, the section 18 of this act, it is guarantees the certain rights such as access to mental health care. So this is the statutory right apart from the fundamental right got under this particular act. Second is about it gives the protection from the inhuman treatment. So the kind of inhuman treatment, many times the mental illness is considered as part of that spirit has attacked a certain person. So there would involve this superstition belief, and it leads to some inhuman treatment like beating, okay, hanging them upside down. So this kind of unhuman treatment given. So this act gives the protection against this kind of unhuman treatment. Next, it is decriminalize attempted suicide. So this is the one significant achievement, and it is very important from perspective of GS4. So where it is gives the person, it is reduce the stigmatization. Okay, not terming the steps taken after the severe mental health as a criminalized attempt. So this is the very important from perspective of GS4. It is the again quite debatable issue. Okay, so now if we see what are the challenges involved in this statutory as well as the constitutional right when it comes to the implementation. So certain there is implementation gap, because we have seen the Supreme Court has given guideline where the student university college have the 100+ students, they need to have the infrastructure, they need to have the human resources, but when it comes to implementation stage, hardly there is the implementation done. Next is about the uniformity and diversity. Supreme Court has given the uniform guideline, again this particular act, which is uniformly applied throughout the India. But if you see the diversity of India, so there is the cultural, linguistic diversity, again the caste diversity, there is tremendous diversity. So there, when it comes to the mental health issue, there are the different reasons, and that many of the cultural specific. So the uniformity guidelines cannot be applied. So that is the one conflict when it comes to the uniformity versus diversity. Next is about the accountability and enforcement. The government has came with the act, they have given the statutory right, but when it comes to the institutions, the institutions are not established. So there is no dedicated institution to enforce this mental health act. So there is the gap when it comes to the enforcement. Also the defining terms. So certain terms are there mentioned in this act. One such term is practices harming mental health. So it is quite a vague term, and it is subjected to interpretation, be it judiciary or the person who will enforce this act. So these kinds of terms, it is creating uncertainty. Next is about the cultural attitude and stigma. So if you see around the cultural attitude, that mental health net, many times it is stigmatized. So the proper precaution has not been taken. So this is the one more issue. Second is last one is the academic pressure. So if you see the mental health issue prevail, it mostly among the student, particularly Gen Z. So if you see the academic pressure, because our academic system works on the marks, okay, not on the skill. So this severe pressure, it is leading to the mental health illness among the youth, which are the very crucial from the perspective of the demographic dividend. So these are the issues involved in the challenges pertaining to the mental health issue. So this is all I wanted to discuss today. Tomorrow I will come with articles that coming in the Hindu and Indian Express that we'll discuss from the men's perspective. Thank you very much.